Welcome to Landmark Chambers webinar, Property Law, Nuts and Bolts, Part 5, Costs. You're probably ahead of me on this because I'm a relatively recent joiner to Landmark Chambers, and so I've so far missed parts 1 to 4. But anyway, it's really wonderful to see that so many of people are joining the session today. Unfortunately, Kate Trainer can't be with us today, but don't worry, Tom and Rupert will still be covering all of the advertised material between them, so we're not going to miss out on anything. As you can see, my name is Ellodie Gibbons and I'm going to be chairing today's session. I'm joined by my colleagues, Rupert Cohen and Tom Morris. As I said, I have two very talented colleagues who are giving today's presentation. It's quite embarrassing looking at how junior they are and what they have already achieved. I'm not sure whether it's Tom or Rupert actually that's going to be speaking first, but Rupert is a leading junior for costs in both the Legal 500 and Chambers and Partners. He's been in the Court of Appeal in 3 cost cases last year, and he's on the Attorney General's B panel for costs. Not to be outdone, Tom Morris has appeared unled in every court up until the Supreme Court. He had a recent win on his own in the Supreme Court in Gibbons and Racusen. He recently acted as sole counsel for the successful respondent in the High Court in a High Court appeal from a Chancery Master's decision to award security costs on a later application. He acted as sole counsel for the successful applicant for a freezing order in the Chancery Division in respect of a prospective costs order following a claimant's failure to pay security for costs, significantly widening the scope of the freezing order jurisdiction and changing the law along the way. He acted for the paying party in the longest running detailed assessment of costs ever, involving a bill of costs in the sum of 53 million and 100 days in court. Despite the assessment being on the indemnity basis, his client, the paying party, were limited to paying 70% of the costs of the assessment. Tom is also frequently instructed to appear for the Lord Chancellor in appeals against the legal aid agency's determinations. So, without further ado, I shall move on to Tom and Rupert, who are going to tell you all about costs.
Right, I'm hoping that you can all see and hear me, and no doubt I'll be told if that's not the case. Thank you very much for that introduction, Ellodie. Over the course of the next 20 minutes or so, I'm just going to rattle through reasonableness, proportionality and summary assessments, and then Tom will carry the torch dealing with security for costs, and then we've divvied up Kate's talk on part 36 between us. So far as reasonableness is concerned, the way that it dovetails with proportionality is that it tends to be more of a all-encompassing, all the circumstances evaluative assessment. It interacts with proportionality, but most importantly, doesn't allow for the application of hindsight. So when you're thinking of the quantum of costs, it might be summary schedule at the end of a contested application, or you may at some point in your careers be dragged into a detailed assessment. You're going to find that the court tends to approach reasonableness first, and that looks at the item of cost that's in dispute, and then contextualizes it at the point at which it was incurred. So just to kind of use an example, if you've gone off to a handwriting expert to opine on whether a particular trust deed had been properly signed or not, the determination of whether that was a reasonable cost is going to be determined as at the facts known to the solicitor at the time. So that encapsulates the difference between the two. One means that you can apply hindsight, one means that you can't. Proportionality has also got its own set of criteria. Again, as reasonableness is a contextual, let's look at all the particular facts as they appear to the decision maker at the time, proportionality means that you look at hindsight and having undertaken that reasonableness assessment, so you've gone through, again, in the context of formal detailed assessment, you've gone through the bill, you've got to a final figure, then you'd be asking yourself, is that figure proportionate having regard to what you see on the screen before you? In a summary assessment, it tends to be done at the end in a slightly more rough and ready fashion. But what it means is that when you've got that particular figure, you're going to be asking yourself whether that figure is proportionate, bearing in mind the relationship it pays to the sums in issue, the value of any non-monetary relief, complexity, additional work, and wider factors. Again, just to use an example, if you're going to, instruct a silk to turn up on a first instance possession claim, that's going to be a classic example for the court to say, well, that's disproportionate, irrespective of how reasonable the decision might have been at the time, albeit that I'm not entirely sure it would ever be reasonable to instruct a silk on a possession claim. Now, the way in which those two principles actually apply in a meaningful sense, so far as we're concerned, is in the bases of cost. You'll all be very familiar with the expressions standard basis and indemnity basis, but it's not often that you're going to be dragged to the definitions in CPR 44.3. Now, there are two salient elements that determine why it is that a standard basis is so much less generous than the indemnity basis. The first is that costs that are disproportionate in amount may be disallowed or reduced even if they're reasonable or necessarily incurred. So in other words, if it was objectively reasonable for you to do what you did, instruct the handwriting expert to go and look at the trust deed, if the cost of that expert was disproportionate with the benefit of hindsight, then that fee is not going to be allowed. The other one is that any doubt as to whether a cost was reasonably and proportionately incurred or reasonable proportionate amount will be applied in favour of the paying party. And it's for that reason that if we kind of cast back, you will often find solicitors in outdated retainers saying things like on the standard basis you'll get 60%, whereas on the indemnity basis you might get more than that. So if we then just juxtapose those two twin principles as against what happens on the indemnity basis, the first point is that any doubt will be applied in favour of the receiving party. And the other is that on the indemnity basis, there's no proportionality test. Again, if you place yourself in that kind of dispute that courts hate with a passion, things like boundary disputes, if you've got a boundary dispute where you've got a real question as to whether costs should be awarded on the standard indemnity basis, you might have issues about offers involved, you might have conduct, you might have material failure to disclose and the like. It makes a huge difference, the receiving party, to get costs on the indemnity basis. One, because they get a benefit of the doubt. Two, because you don't have proportionality. And the classic argument that's always run by the paying party in the context of a boundary dispute is, this land is worth a negligible amount of money. Boundary disputes aren't legally complicated. And for that reason, the proportionate sum for a 3-day trial where your client's racked up £250,000 should be £55,000. So to rob them of that argument is obviously something that your client is going to want. But the final one comes in CPR 318, which provides that in any case where there's a cost management order, when assessing costs on the standard basis, the court will not depart from such approved or agreed budget unless satisfied that there is good reason to do so. And everyone on this webinar knows full well that the exercise of cost budgeting can be pretty variable at best. It depends on the judge, it depends on the information you have, and it will depend on the issues as at the date of the cost management order at the CMC rather than actually as they transpire to be. And if, as again will often be the case in a what I would classify as an undignified dispute, boundary disputes are always undignified, you're going to find the court allowing very little on a cost budget because they use cost budgets as a means of making litigation more expensive. In other words, it promotes things like settlement. If you think, well, it's going to cost me 300 grand to get there, but my cost budget's only in the sum of 150, you're going to be more inclined to find the middle. And for that reason, indemnity cost becomes hugely important because if you get indemnity costs, the cost budget is irrelevant. You put the cost budget entirely to one side. Whereas if the cost awards on the standard basis, then the court's not going to go from the budgeted phases unless there's good reason. And if your budgeted phase for witness statements is £25,000 and you end up running 65 grand's worth of costs, obviously there's 40 grand that rides on the difference of the basis of costs that the court awards. And finding good reason to move from the budget where there is a standard basis is actually quite difficult. It's not a kind of, it turned out this was very complicated or their disclosure was more than we thought. That's not really going to get you very far. It tends to need to be something far more dramatic, not least because whenever you turn up and say, well, the disclosure was much more extensive and therefore the statement needed to have more time spent on it, you're just going to get the other side saying, well, you should have applied to revise your budget. So there is a substantial difference between the two in terms of the cost outlay. And again, the principal reason why you might get indemnity basis rather than standard basis is going to be because offers have been beaten. It's going to be conduct. I had a rights of way dispute at the middle of last year, which lasted 3 days, and we got an indemnity cost award because the other side failed to disclose some very important conveyancing documentation. It's issues like that that tend to elevate what would otherwise be a standard basis order to an indemnity basis order. Reverting then to summary assessment, which is the kind of third limb of what I'm going to be talking about. The form is an N260, and it's that classic form that we've all seen and very familiar with. You've got right at the top, it'll say schedule in respect of, and someone will write in the particular hearing, might be specific disclosure, it might be an appeal hearing. You'll then set out the identity of the fee earners, the amounts that they charge. You then have attendances on client, attendances on others, attendances opponents, work done on documents, time spent on hearing, capital brief, and then the final figure. In terms of when it is that it should be filed and served, fast track trials not less than 2 days before the trial, and all other hearings not less than 24 hours before the time fixed for the hearing. To be honest, schedules of costs are often late. You can kind of make a great song and dance about it if you want. By and large, they're not complicated documents, so actually reading it doesn't really take more than 45 minutes to understand properly. But there's a technical point that you can take, and sometimes barristers do take, about late service of statements of costs, and you'll see the case on the third bullet point of Simpson and MGN, where the court just knocked down 25% simply because it was late. And in other circumstances, the court will send the cost to be assessed for detailed assessment, but expressly provide that the receiving party pay the costs of the detailed assessment, which is contrary to the rule in 4720, which provides that the paying party will pay the receiving party's cost of the detailed assessment. Final bullet point is simply that if you get to the end of the hearing and the court wants to conduct a summary assessment, what the court can't do is just list it in front of somebody else. It's going to be a summary assessment. It's got to be before the same judge. Again, you'll see on the top bullet point, schedules the N260. Some solicitors like to have their own bespoke schedules. You never really understand why. Stick to the N260. The signature on the final page is really important. That is the signature of a fee earner who is going to be an officer of the court, expressly stating that the costs stated above do not exceed the costs which whoever the client is liable to pay in respect to the work this statement covers. Counsel's fees and other expenses have been incurred in the amount stated above and will be paid to the persons stated. Now, the reason why that signature is so important is because it is the representation to the court by an officer of the court that the costs in that schedule are all costs that the client is liable to pay for the particular subject matter that the schedule covers. And having stated that, you'd think that it'd be pretty rare to find things in a schedule that shouldn't be there. But as the final bullet point shows, and I'll go on to give you some examples, it is absolutely staggering the number of times that solicitors put in cost schedules, items that should not be there. And it's equally staggering the number of times that counsel don't bother to look or read through a schedule and ask themselves those questions. So, point to challenge. Has it been served correctly? That goes back to the timelines. Has it been signed? It has to be signed. And more importantly, has it been signed by the right person? It needs to be an officer of the court. It's got to be a fee earner. It's not to be, some litigation friend or whatever else it might be. And that always, often claimed, often should not be claimed. There should not be VAT in a summary schedule of costs where the client is able to recover the VAT as input tax. Now, what that actually means is if the client is registered for VAT and is trading, so that in reality is going to be a company. So if your client's a company, or if your client is a sole trader who is actively trading, they are going to be paying VAT. The VAT that their solicitors seek from them, they can then take that equivalent sum and reduce their VAT liability to the exchequer by the equivalent of amount. So what that means is where the particular client can recover the VAT is input tax. Input tax basically means you reduce your output tax, and it shouldn't be in a schedule. So if you ever have a client that is a company, don't put VAT. I mean, if it's not trading company, if it's a non-trading company, VAT is justified. But in the broad run of things, it'll mean that if the client is a company and VAT is being charged, it shouldn't be there, and it is almost invariably included when it shouldn't be. And what that will mean is If you're the paying party, you're paying 20% more than you should, and if you're the receiving party, you get a 20% fillip when, frankly, you shouldn't. The next is attendances on others and attendances at hearing. Quite often says attendance at hearing, and people just stick down 8 hours when it's a 25-minute possession claim, you know, that classic first instance possession claim. So look at the attendances at hearing. Attendances on others, you just get a kind of random figure that's put in there. And the way to deal with it, and one of my bête noirs is on summary assessment when I see other barristers who, because they identify themselves as specialists in a given area and don't bother to do the cost sorting up on the side, never actually bother asking their client what the composite parts of the schedule are. What you should be doing to your barrister is prodding them in the back and say, ask whoever it is that's representing the other side what the attendances on others are. And so you say to the court, you know, 14.6 hours has been spent on attendances on others. I understand that there was a matter of listing with the court, but I have no idea what the rest of that is. And can my learned friend explain it? And you see them go bright red and desperately flaring around without a clue, basically, what it was. So attendances others often should be reduced. Counsel and solicitor duplication. Solicitors on appeals shouldn't be spending time on law. That's generally speaking not really recoverable. And what you'll often find is for a distinct hearing, and you look at the top of the front page and it will say these are costs incurred with respect to the summary judgment application to be heard on day X. If you actually go through the work done on schedule, you're going to find so much in there that has absolutely nothing to do with the hearing in question whatsoever. So a classic example would be, you know, a specific disclosure application that's been issued. And if you actually look at the schedule of work done on documents, it's got things like considering the defense or, you know, time spent reviewing counsel's particulars of claim. That has absolutely nothing to do with the application for specific disclosure in respect of which the schedule has actually been filed and served. So these are all points that you've got to be alive to as solicitors, partly because it's your professional duty to your client, but also because barristers are often embarrassingly bad at it. And you've got to prompt them to make sure that they're sufficiently proactive when it comes to it. As I'm sure many of you know, the guideline hourly rates were updated in October 2021. And in your white books, 44 SC, I think paragraphs 14 to 28, accompanying the new guideline hourly rates, which I'll just refer to very briefly at the end, is the updated guide to the summary assessment of costs. And it's actually a, and you know, I fully accept we're talking about costs here, so it's hardly going to be very interesting, but it's actually quite an interesting and quite a useful document. I've taken on this slide and the couple of slides succeeding this, the relevant paragraphs that I think are most interesting from the guide. But ultimately, if you're sitting there and you're worrying about costs and you're worrying about summary assessment, just read the guide. It's got 12 decent pages that deal with reasonableness, deal with proportionality, deal with the type of costs that can be claimed, can't be claimed, and it's quite a useful reference point which sits there in the white book, totally ignored by everybody. Assessed costs can be paid within 14 days. Second bullet point, costs of postage, couriers, telephone calls, stationery, and photocopy are not recoverable because they're in the hourly rate between the solicitor and the client. No allowance should be made for reading incoming routine correspondence. So when that question's asked as to what attendance or other is, and whoever it is stands up and says, by the way, it was included time spent reading correspondence from the client, that's the point at which you say, no, that's not recoverable as a matter of cost law. The final bullet point is important. And this is a change from the previous guide. It says the cost which the paying party has incurred for its own representation may be relevant when considering the reasonableness and proportionality of the receiving party's costs. And previously, before this particular edition of the guide, when someone used to say, well, my costs are very much lower, the other side would say, well, your costs are your costs, but that's irrelevant to the exercise. Well, actually, that's no longer the case. And what that'll mean is there's a tactical exercise that you will need to undertake with your clients when you're working out how it is to pitch your own costs. If it's an application that you think you're going to lose, but has to be fought, then it makes sense to put in a very low cost schedule, because if you're going to lose, you're then going to use that as the basis for saying to the other side that their costs should be lower. Now, I'm not suggesting you deliberately exclude categories of costs, but you always get categories that could fit into one or fit into another, and you're going to be a little bit more conservative about what you put in your own cost schedule as a consequence. So there's much more of a tactical angle to the exercise of how you best present the challenge to the other side's cost schedule than there historically was. The next one is counsel's fees. Barristers tend to be very shy about the side's brief fee. the reason why they do it is because I think a lot of my peers will look at a brief fee and think, well, you know, I don't want to stand up there with somebody who might be in my chambers or who I know well, or whatever else it might be, and kind of say they're not valued for money. But that's actually not what you're saying. You're not saying that because the exercise of ascertaining what the reasonable and proportionate counsel's brief fee is, has got absolutely sweet FA with what they've charged, other than, for obvious reasons, you're not going to allow more than they've charged. The reason why it's got sweet FA to do with that is because of the case of Simpson's motor sales, which provides that the actual exercise to define what it is that a reasonable and proportionate brief fee is to ask what the hypothetical counsel capable of conducting the case would have charged. So to go back to that example I gave at the outset of this, if you're going to instruct Silk to attend a possession, claim, which is pretty unremarkable, the short answer is that the hypothetical counsel would have charged, 250 quid or whatever the going rate is for a 5-minute bulk possession hearing these days, because the hypothetical counsel is going to be reasonably proficient and can do the cases itself, because by and large possession hearings aren't particularly complicated. So it's not a matter of saying to the other barrister, you're not value for money, even though many are. It's much more an exercise of saying, well, if you tended this to market and you've got someone who could do it and do it reasonably well, how much would they charge? The final bullet point is a totally bizarre rule of thumb, which appears in every single edition of the guide and makes no sense to me whatsoever. But apparently, junior counsel's reasonable fee will be 1/2 the reasonable fee of leading counsel, which, frankly, totally defies the kind of is totally inconsistent with the logic of identifying what's reasonable and proportionate. But it remains there in the guide, so worth knowing, even if it doesn't make any sense. The final one of my slides before I hand on to Tom deals with the rates themselves. The previous rates had London 1, 2, National 1, 2, 3. We've now got London 1, 2, 3, National 1, 2. London 1 is no longer strictly postcode specific. You'll see in the bottom left that London 1 means very heavy commercial and corporate work by centrally based London firms. Previously used to be strictly geographically limited to the City of London. If you take London 1A, which is the highest you're going to get in terms of a summary assessment, it's 512, which frankly is not that much in the context of what solicitors charge. Certainly when they did the exercise of identifying what the figure should be, there were lots of firms saying it should start with a 7 or an 8, and the guide has come in at 5. So there are going to be major reductions that you can make with reference to the guideline hourly rates. And the case of Samsung Electrics, which I haven't actually included on this slide, but when I come back to finish off on fraud bank offers, I'll actually read out the citation, provides the Court of Appeal said that given that the rates have been updated, if a receiving party wants more than the guideline hourly rates, they need to provide a cogent justification for why that is, which, and in the same vein, the Court of Appeal said, the type of case itself doesn't constitute a cogent reason. So these rates are now relevant. The previous rates were October 2010, and frankly, we all ignored them because they were so out of date. So the questions you're going to be asking yourselves when you're looking at these rates are, if you're the receiving party, is there a cogent explanation for going more than these rates? In which geographical sphere do you actually fall? Because it's against that particular sphere that you're going to be dealing with. You're going to find in the context of property work, which is what Tom and I do in the main, that you're not often going to be in London 1, bluntly. I mean, very heavy commercial and corporate work has been deliberately defined because it's aimed at commercial court more than it is in the business property courts Chancery Division. So you'll tend to find yourself starting in London 2, which is for all other central London work, and then London 3, and then National 1 or 2, depending where the solicitor's firm is. And that brings me to the end of this particular segment of it before I come back in with a final flourish in the second half of what would have been Kate's talk. So over to Tom.
Thank you, Rupert. Again, I hope everyone can hear me, and I'm sure someone will let me know if they can't. I'm going to talk about security for costs and also payments on account, but I'm going to do them in a different order and start with payments on account. Now, there are essentially two issues with payments on account. The first is, when can you ask for one? And the second is how much you should ask for. And this is fairly important because it's very easy to forget actually to ask for a payment on account or to put it in your draft order. So the source of the power to order a payment on account comes from Rule 44.28 of the CPR. And the wording of it is very important. It says, where the court orders a party to pay costs subject to detailed assessment, it will order that party to pay a reasonable sum on account of costs unless there is good reason not to do so. So what that means is that a payment on account is usually going to be ordered unless there is good reason not to. And this formulation of the rule essentially elevates it almost to a presumption. But that doesn't mean the payment is automatic. Wherever I go for, or the place that I normally go for authority on when the court might not order a payment on account is the decision of Lord Justice Christopher Clark, sitting actually in the commercial court in Excalibur Ventures. And then he said this, which is a very useful quotation. In determining whether to order any payment and its amount, account needs to be taken of all relevant factors, including the likelihood, if it can be assessed, of the claimants being awarded the costs that they seek, or a lesser, and if so, what proportion of them, the difficulty, if any, that may be faced in recovering those costs, the likelihood of a successful appeal, the means of the parties, the imminence of any assessment, any relevant delay, and whether the paying party will have any difficulty in recovery in the case of overpayment. Just worth noting as well that conduct can also be relevant, and so can the existence of a potential set-off. And just recently I have opposed an order for payments on account being made on the basis that there was some doubt about the receiving party's ability to make good any overpayment. That was where I was acting for a local housing authority against one of its tenants. And I've also defeated an application for a payment on account by relying on the existence of a set-off of my own client's costs. So these are relevant things. You should keep them in mind because it does not automatically follow that a payment on account will be ordered where costs are going off to detailed assessment. I've gone too far. What happens if the party who is ordered to make a payment on account doesn't pay it? The starting point, if you have been ordered to make a payment on account, is that you need to have a think about whether you're going to be asking for permission to appeal. Because if you are going to ask permission to appeal, you can also apply to stay the order that you make a payment on account. However, it's important to bear in mind that that might be a bit of a long shot. As Mr. Justice Leggett said in the Kazakhstan case, solid grounds are required to justify a stay pending an appeal, such as that absent a stay, the appeal would be stifled. So in order to show stifling, the onus is on the party who's been ordered to make the payment to adduce sufficient evidence to show that their appeal will be stifled if the order to pay is not stayed. But from the receiving party's point of view, if someone doesn't pay a payment on account, you've got a judgment which is enforceable just like any other. But there are a couple of other weapons in your arsenal. You can apply, first of all, for an order that unless the payment on account is made, the paying party shall be debarred from participating in detailed assessment proceedings. And you can also ask for an unless order in relation to them proceeding with their appeal. So those are two things to bear in mind because they might be more immediately effective than trying to enforce your costs order. Again, a point to remember if you're the paying party is that if you are going to struggle to make the payment, you can also apply to pay it in instalments, which might ease the pressure slightly. So the next big question is quantum. What is a reasonable sum? And again, Christopher Clark, LJ in Excalibur Ventures, has expressed the test like this, where there is no cost budgeting, so you don't have a cost budget, a reasonable sum would often be one that was an estimate of the likely level of recovery subject to an appropriate margin to allow for error in the estimation. This can be done by taking the lowest figure in a likely range or making a deduction from a single estimated figure or perhaps from the lowest figure in the range if the range itself is not very broad. Now that's fairly wordy, but in practice, what it means is that if you've got an order for costs to be assessed on the standard basis, you'd be looking at asking for a payment on account in around the 70% range. And if you've got costs on the indemnity basis, you'd probably push higher up to about 85%. But where you've got cost budgets, it's much easier because the most recent approved or agreed budget should always be the starting point for quantifying a payment on account. And a useful case to keep in your back pocket is McInnes and Gross, because there, Mr. Justice Coulson awarded 90% of the budgeted sum on the basis that a 10% reduction was, quotes, the maximum deduction that is appropriate in a case where there is an approved costs budget. So if you've got cost budgets, the court has already reached a view about the reasonableness and the proportionality of the costs. That then is your starting point, and you should hope to get a payment on account which is much closer to your budgeted figure. That is all there is really to say about payments on account. The two key takeaways are don't forget to ask for one and know how much you're asking for. And if you've mastered that, frankly, you've mastered the art of payments on account. So coming then on to security for costs, which is a little bit more of a meaty topic, starting perhaps to jazz things up a little bit with a bit of judicial philosophy. So the system of justice which prevails in this country, it is said, is founded on the premises that the interests of justice are ordinarily best served if successful litigants recoup the costs of their litigation, or the bulk of those costs, and unsuccessful litigants pay them. There is a real difference between the position of claimants, for whom issuing proceedings is always a voluntary act, and defendants, for whom being sued is not. And that's how Lord Justice Nugent put it. So that's a very good case to keep in your pocket if you are going into court to ask for a payment on account. Start by reminding the court of this important public policy principle. But keep in mind that that is not the end of the story. As Lord Justice Ward put it in Rado and Houston, the obtaining of an order for security for costs is a rather special form of order. It is intended to give a claimant a choice as to whether he puts up security and continues his action or withdraws his claim. That choice is meant to be a proper choice. The making of an order for security is not intended to be a weapon by which a defendant can obtain a speedy summary judgment without trial. And keep that in mind, because that quotation is going to be relevant when we come and look at the issue of the timing of applications very shortly. So a few key opening points. The principal source of the power is now section 2 of part 25 of the CPR. And most applications for security for costs, almost every application for security for costs is going to be made under this part of the CPR. It's very important to remember that only a defendant to a claim may apply. A claimant cannot obtain security for costs unless, of course, someone has brought a counterclaim against them, in which case they stand as the defendant in the case of that counterclaim. The other thing to remember, and it's important always to advise clients of this, is that the power is discretionary and it will only be exercised where the court is satisfied, having regard to all the circumstances of the case, that it is just to make such an order. And so there are 3 stages to any application. The first one is to consider whether you can satisfy one of the conditions in Rule 25.13(1). The second is the discretionary stage. You have to consider whether it is just to make such an order. And then the third stage, if you get over those 2 hurdles, is to consider the quantum, the manner of security, and the time within which it is to be given. So the conditions, or the gateways for getting over or getting across the line to make an application for security for costs, are set out in Rule 25.13. I've written them on the screen. I'm afraid there is just not enough time in the allotted time that we have to go through them all. So what I'm going to do is focus on condition C. The claimant is a company or other body, whether incorporated inside or outside Great Britain, and there is reason to believe that it will be unable to pay the defendant's costs if ordered to do so. In my experience, that is the ground that property practitioners are most frequently going to have cause to rely upon, and it's also one of the more fiddly ones. Now, the starting point is to focus on what the test is. Critically, the test is not the balance of probabilities. So what that means is you do not have to prove to the court that on the balance of probabilities, a claimant company will be unable to pay a defendant's costs if ordered to do so. The test is something different. It's about reasonable belief. And Lady Justice Arden explained the difference in Giant House Capital as follows. She said, in my judgment, there is a critical difference between a conclusion that there is reason to believe that the company will not be able to pay costs ordered against it, and a conclusion that it has been proved that the company will be unable to pay costs ordered against it. In the former case, there is no need to reach a final conclusion as to what will probably happen. In the latter case, a conclusion has to be reached on the balance of probabilities. So the important thing to remember is that the test that the court has to address is a lower one than balance of probabilities. So what sort of evidence do you need to think about getting together to support your application? A couple of pointers. Liquidation is capable of being prima facie evidence of inability to pay, unsurprisingly, and as is balance book insolvency, if you can demonstrate that from land registry documents. Something that's very important to bear in mind is that illiquid assets should be left out of account. The question for the court is whether the company would have sufficient liquidity to pay costs when required to do so. And this is important in some cases. Let's give a recent example. I recently made an application for security for costs, and it was defended on the basis that the claimant company's assets were sufficient to make good any costs order. And perhaps slightly esoterically in this case, the claimant company's assets were 2 antique silver soup dishes, which it said were good enough to meet the costs of High Court litigation. That argument was rejected and security was ordered to be put up in money. Now, if you don't have any evidence of liquidation per se, and you don't have any other evidence about the company's standing, the best place to go is Companies House, where you can find the necessary documents to carry out an analysis of whether you think that the evidence is good enough to establish that there is sufficient reason to believe. Now, it sometimes is the case that there isn't that evidence, either because it's just not available on Companies House or because the company is incorporated outside of the United Kingdom. Now, in this case, all you can do is ask for the evidence. And it is important that you do so if you're thinking about making an application for security. And the case to keep in mind is SARPD Oil International Limited and Adax Energy and another. And it's very difficult to understate the importance of this case, which should be known about by anyone who acts for people who get sued by companies. The principle that comes from that case is that where a claimant has been given the opportunity to adduce evidence that it can pay a defendant's costs and deliberately refuses to do so, there would be every reason to believe that if and when it is required to pay a defendant's costs, it would be unable to do so. And I've relied on that principle recently, and a court has made an order for security for costs on the basis that the claimant company had deliberately, or if not deliberately, rather too conveniently failed to adduce any evidence to the court to satisfy it that it would be able to pay costs when ordered to do so. A word about the merits of the case. In general, as is stressed in the Commercial Court Guide, an investigation of the merits of the claim should be avoided. But that is not the end of the story, because if the strengths and the weaknesses, pause to stress, and the weaknesses, can be discerned without prolonged examination of the evidence, then they can be taken into account. And where a claimant can show, on the basis of that inquiry, that its claim is highly likely to succeed, the court will in general make no order for security, or an order for less security than would otherwise have been ordered. Now, I've relied on those authorities successfully in resisting an application for security for costs, where the claim was all about whether a Section 146 notice was valid or not, and all that the court needed to do was to look at the face of the notice and a few uncontroversial witness statements, and the court was satisfied on that basis that it could see that the claim was highly likely to succeed, and it dismissed the application for security on that basis. So although in general the merits of the case should not be investigated, there are cases where you might be able to persuade a court to take them into account. And ditto, if you are making an application for security for costs, if the defence is so hopeless and that can be demonstrated without a detailed inquiry, again, that is something that you might be able to persuade the court to take into account when deciding whether to exercise its discretion. A word of warning on that, though, which is that where a claim is going to turn on oral evidence rather than on documents, it's very unlikely to be appropriate to investigate the merits, and there is authority to that effect. Now on to another important thing, which is important to keep in mind if you are met with an application for security for costs. And the principle is neatly expressed by Lord Justice Peter Gibson in this case. The court will properly be concerned not to allow the power to order security to be used as an instrument of oppression, such as by stifling a genuine claim by an indigent company against a more prosperous company, particularly when the failure to meet that claim might in itself have been a material cause of the plaintiff's impecuniosity. But it will also be concerned not to be so reluctant to order security that it becomes a weapon whereby the impecunious company can use its inability to pay costs as a means of putting unfair pressure on the more prosperous company. Now, this comes up in my experience in cases where a landlord has re-entered a property and a corporate tenant sues it for possession, damages and injunction. Now, in such a case, it may well be that the corporate tenant has been prevented from trading, and that is the cause of its impecuniosity. Now, in that case, it's very tempting if you're the landlord to make an application for security for costs, especially if the merits of the trespass claim are seriously disputed. But where you are the claimant company, this is an important principle in that case to bear in mind. But it is important to remember that the onus is on you, the claimant company, to provide that it is more than, to prove that it is more likely than not that the claim will be stifled. It's not enough to show that that is just a risk. You actually need to adduce cogent evidence to show that an order for security for costs is going to shut you out. And in that connection, it's important to bear in mind that you might want to give full and frank disclosure as well about your directors and shareholders' means. Coming now on to timing, which I foreshadowed earlier, there's a quotation here from Mr. Richard Millett, QC, in a case which I'm not going to attempt to pronounce. But the essence of this quotation is that delay in making an application can be taken into account. The later you make the application and the closer to trial you get, the more oppressive it may be to order security to be put up. Now, if you are trying to defend an application for security on the basis of delay, there are a couple of things to keep in mind. The first is when you are sued by a company, you immediately should consider whether to apply for security, or at least take steps to obtain sufficient information to make that decision, keeping in mind the SARPD oil case, because ideally you want to be in a position to make your application for security for costs in advance of the first CCMC. It's important to note that there is no rule that applications for security should be made as soon as possible, but it is still highly relevant, and you see it cropping up again and again in reported cases. However, even where an application is arguably made late, you can get around that sometimes by pointing to the fact that you've been threatening to make the application for security for costs from an early stage, so the defendants had good notice of it. And it's also worth noting that a party trying to defend an application on the basis of lateness needs to prove some disadvantage arising out of the delay. You need to have some evidence that will show that you can't gather the security. Now, in many cases, it may be said to be oppressive to require a claimant to find large sums of money just before trial, but again, that must be evidenced. And what the court might do is to order the amount of security to be reduced to take into account lateness, or to order security only in respect of future costs. The last important principle, I think, to bear in mind is the Crabtree principle, which is often forgotten about, but security will not usually be ordered where, if it were to be unpaid and a claim struck out, the issues would be litigated anyway on the counterclaim. The test is whether the counterclaim has independent vitality. So if the counterclaim is merely a defence to the claim, then security should be ordered. But if the counterclaimant is going beyond self-defence and actually launching a claim of their own, the court will usually order no security, or order that both sides put up security. But it's an important one to bear in mind, again, where you are a claimant and there is a counterclaim against you and someone tries to resist your application for security. Coming now on to quantum, this is always, again, in the discretion of the court. Important to bear in mind that it can be ordered in tranches. It's not an exact science. It's to be approached fairly robustly. Budgeted costs, as with payments on account, are always a sensible starting point. And what the court is going to do is make an estimate of the monies that are likely to be allowed on a detailed assessment on the standard basis. Now, another point to keep in mind is that where there is a clear case that costs would be ordered on the indemnity basis, security can be quantified on that basis. And that's what we persuaded the Chancery Master to do in Santina. That was upheld on appeal to Mr. Justice Marcus Smith. Lastly, then, forms of order. There is a standard form of order, PF 44, and that actually provides for security to be paid on an unless basis. And the form of order is written out there. However, it's important to keep in mind that that is contrary to what is recommended in the Commercial Court Guide and the Chancery Guide. What they say is that an unless order is quite draconian. And so instead, they propose that there be an automatic stay with liberty to apply to strike out if security isn't put up. And the sort of order that you're making there is set out on the screen. And that is more appropriate when you're in the Chancery Division or the Commercial Court as opposed to the County Court. Lastly, what happens if there's non-payment? There is a case called Cook and Venulum Property Limited, Investments Limited. It's a decision of Paul Morgan. Now, he says there that a freezing order cannot be used to secure costs, and that you should not get a freezing order where there is no underlying cause of action for money. But, and this is the change of law that has been introduced in the Santina appeal that I did recently, Mr. Justice Marcus Smith held that a freezing order that can be made in support of a right to strike out a claim following non-payment of security for costs where there is evidence of dissipation of assets to avoid the cost consequences of non-payment. So in other words, provided you have a right to strike someone out where they have not paid security and the other requirements of the freezing order test are met, you can get an order which prevents the party walking away from the litigation and dissipating their assets so that they avoid all of the consequences of that. Right, that is security for costs. I'm now going to move on to cover the first part of the talk that Kate Traynor was going to give you. So doing my best to stand in for her and heavily reliant on her notes, here we go. I'm going to canter, I think, quite quickly through the framework of Part 36 before handing over to Rupert to talk about some more conceptual things that arise out of it and some tactical pointers. So first of all, when can a Part 36 offer be made? The circumstances are on the screen. So in both money and non-money claims. So for property practitioners, useful to keep in mind that you can make Part 36 offers in boundary disputes, in respect of the whole or part of the claim, or in relation to an issue that arises in the claim. Also on appeals or cross appeals, in respect of liability alone, leaving the issue of amount of damages to be dealt with later, which is also useful in sometimes trespass claims and also boundary disputes, and also in respect of counterclaims and any additional Part 20 claims. Now, a critical thing to bear in mind is that there are strict requirements for a Part 36 offer. And if you fail to make your Part 36 offer in the prescribed way, it will not be a Part 36 offer and Part 36 consequences will not attach to it. So the requirements are very clear and you should always go to Part 36 to check them. The offer needs to be in writing. It needs to make clear on its face that it's made pursuant to Part 36. It must specify a period of not less than 21 days within which the defendant will be liable for the claimant's costs. That's called the relevant period. Note that relevant period can be longer than 21 days. And it must state whether it applies to the whole or any part of the claim. And it must also state whether it takes into account any counterclaim. Mitchell and James is authority for the proposition that a failure to comply means it's not a Part 36 offer, but Huntley and Simmons is authority for the proposition that a court will still take it into account when deciding generally what the cost consequences are. If there's any doubt in how to meet these, oops, I've gone far too far. If there's any doubt in how to meet these requirements, then rely on the prescribed form, which is set out at the bottom of the slide that I just flew away from, and it is form N242A. Next, acceptance of a Part 36 offer within the relevant period. It's important to keep in mind the differences between within the relevant period acceptance and acceptance outside of the relevant period. So if a Part 36 offer is accepted within the relevant period, the cost consequences are as follows. The claimant is entitled to costs up to the date of acceptance on the standard basis, and they're also entitled to the costs of any counterclaim. The defendant must pay the claimant those costs within 14 days, and if they don't, the claimant can enter judgment against them and then have something which it can enforce. If the parties cannot agree on the amount of costs, then if proceedings have been issued, you have a cost order deemed to have been made under Rule 44.9, and your costs will then be assessed on the standard basis. Now, if you are outside of the relevant period, whether that period is stated to be 21 days or some other period, then different things happen. There, what happens is that the parties have to agree the liability for costs, and failing agreement, the court has to decide that liability for them. Now, there is a presumption in those circumstances, which is that the court must award the claimant its costs up to the date of the relevant period expired, and that the offeree pay the offeror's costs after that date to the date of acceptance, unless the court considers that it is unjust to do so. Now, there are some useful cases on out of relevant period acceptance. And there is some discretion for the court. So in the Optical Express Limited and Associated Newspapers Limited, the court awarded the defendant offeror its costs on the standard basis for a period up to the expiry of the relevant period and indemnity costs thereafter. And the claimant did not therefore recover any of its costs. And in Palette and MGN Limited, Ms. Pallet's Part 36 offer was accepted one day after the expiry of the relevant period. MGN claimed that since the offer was accepted outside the relevant period, it was entitled to invite the court to consider liability. However, the rules require that unless it is unjust to do so, the court must order that the offeree, which was in that case the defendant, pays the offeror's costs for the period from the date of expiry of the relevant period to the date of acceptance. MGN argued that it would be unjust to order normal cost consequences as Ms. Pallett had failed to engage properly in the settlement process after the claim was issued, and it had made a number of offers, but the court found that Ms. Pallett's decision to wait for full disclosure in order to value her claim was a sensible view to adopt, and therefore it did order MGN to pay all of her costs of the proceedings. The court did issue a word of warning in that case, which is important to keep in mind, which is that it turned largely on its facts of Ms. Pallett pressing for disclosure to value the claim, and the court warned that this should not be taken as a green light for all claimants to decline to enter into negotiations before disclosure is complete, and that claimants should not seek to apply that case too generally. In the case of a defendant's Part 36 offer, we next have to consider what happens if it's not accepted and the trial goes ahead. What happens then is that if the claimant obtains a more advantageous judgment than the defendant's Part 36 offer, the court will apply the usual principles in making the costs order. If the claimant fails to obtain judgment that is more advantageous than the defendant's Part 36 offer, and it is made more than 21 days before trial, then unless the court considers it unjust to do so, the claimant will be liable to pay the defendant's costs from the date of expiry of the relevant period plus interest on those costs. And in the case of a claimant's Part 36 offer, if the claimant obtains judgment that is not as advantageous to the claimant's Part 36 offer, but equal to the defendant's Part 36 offer, the court will apply the usual principles in making the costs order. If the claimant obtains judgment that is at least as advantageous as the claimant's Part 36 offer and the offer is made 21 days before trial, then unless the court considers it unjust to do so, it will order that the claimant is entitled to interest on the judgment at no more than 10% above the base rate from the expiry of the relevant period onwards, its costs on the indemnity basis, interest on those costs not exceeding 10% above base rate, and an additional amount of up to a maximum of £75,000. So those consequences are very important, and it's very important for practitioners where you're in this territory to scrutinise very closely what the rules provide for. There's a useful table here which set out the Part 36 consequences in different circumstances and note the distinction between claims for money and non-money claims where Part 36 consequences can bite on awards of costs. Now, a question arises, what does the court consider to be unjust? Because the court has to take into account all the circumstances of the case, including the terms of any Part 36 offer, the stage in the proceedings when any offer was made, the information available to the parties at the time of the offer, the conduct of the parties, and whether it was a genuine attempt to settle the proceedings. And these are the things that you need to keep in mind and have a think about when you're attempting to persuade the court that it would be unjust to order Part 36 consequences. And then the court has wide discretion. So key points to remember. If you're making a Part 36 offer, make it as clear as possible. Use the rules as a checklist. Keep a record of what Part 36 offers have made, because offers which are not withdrawn by notice will remain open to acceptance. This is particularly important if you're taking over the case from another firm and you need to establish what's happened before you come on the record. If you're making an offer to settle or accepting a claimant's offer, then you need to bear in mind the need to make the payment within 14 days or you'll get judgment entered against you. And if the offer is not accepted, the important question on costs is not which party has won, but whether the eventual judgment is at least as or more advantageous than the offer. So that is the particular quirk of the Part 36 code, which is why it is so important to practitioners. And on that note, I am going to hand over to Rupert, who is going to take over control of the screen, and I'm going to turn my camera off.
Thanks, Tom. That was typically inspiring. It's also just occurred to me that in divvying up Kate's talk, I've absolutely sold you up the river because I've only got 3 slides to get through. I mentioned when I was doing my initial talk that when you're dealing with guideline hourly rates and summary assessments, This court of appeal authority that you need to have a clear and compelling reason to get more than the rates themselves. The case itself is Samsung Electronics and LG Display, and the reference is 2022 EWCA Civ 466. 2022 466. You've got 5 cases on the screen. I'm just going to give you one line to take from each. They're all Part 36 cases. London Trocadero was Part 36 offer was sent by email in circumstances where, and I think it's perhaps direction 6A off the top of my head, the other side hadn't indicated that they were prepared to accept service by email. The argument was run that the Part 36 offer was not validly served and therefore the consequences shouldn't apply. And the court said under CPR 310 it had power to remedy the error, so to speak. The salient, and did so because there was no prejudice to the other side who had actually acknowledged the Part 36 offer. Selling point under that case, London Trocadero, is if you're going to go down the Part 36 route, make sure you properly serve it in accordance with the CPR. Adams and Options is quite a good one, which is a case which related to pensions transactions of absurd complexity. But the salient point to take from that is Part 36 offer, which to be effective in the sense that there's a binding contract between the parties requires consequent steps, can still be valid. So both that case and it relies on previous case law, which in the context of property law is relevant to the context of Section 2 and Part 36 offer, which wouldn't have been sufficient for purposes of Section 2 of the Property Miscellaneous Provisions Act. And in both that case and in Adams' cases, the court said Part 36 offer was valid, even though there were subsequent steps that would have been required for that offer to have eventuated in a binding contract, because they're supervening or other statutory regulations or controls that provide that a contract won't be effective unless X, Y, and Z is done. So even if that is not part of Part 36 offer, it can still bite, which is very useful when you are trying to compromise things like boundary disputes and you're worried about dispositions of land under Section 2. Telefonica UK Limited is there simply for the proposition that when you're thinking about the uplifts in 36.17.4, and the court has to apply them unless it's unjust. When you're looking at unjustness in the context of interest, the way in which to deal with it is for the court to allow a lower rate of interest rather than simply say, no, I've decided I'm not going to allow any interest at all. In other words, what you can't do when something is unjust is cherry pick the uplifts and identify the ones you want. You've got to allow them all, although on interest, if the court takes the view that 10% or 8% or whatever it is too great, it can allow a much lower rate of interest. Essex County Council is authority for the fact that that final paragraph you see in so many pro forma Part 36 letters, which says, if there's for some reason you think this is non-compliant, please let us know, is entirely irrelevant. The offeror tried to run the argument that the other side were stopped from claiming a Part 36 offer was non-compliant because there was that boilerplate end paragraph that says if there's something in here that you think is wrong, please let us know. And the court said it's not just insufficient to found estoppel, this is totally inconsistent with Part 36 regime. If you're going to make the offer, you've got to sort your own house out. The Jovelin and Burgess is there partly for transparent self-promotional purposes because I was in it, but also because it provides that it confirms what we already know, which is that a defendant's Part 36 offer, when compared to the benefits of a claimant's Part 36 offer, is very much less attractive. Defendant's Part 36 offer, if you beat your own offer, you get a standard basis cost basically from the point at which the offer is made. But, that's absolutely nothing when you compare it to the uplifts that a claimant gets. So as much as one would like to think that the Part 36 regime is as beneficial to the claimant and the defendant, it's not really. Frankly, a claimant faced with a defendant's Part 36 offer can be infinitely more cavalier than a defendant faced with a claimant's Part 36 offer. I'm now just going to deal with called bank offers. Called bank offers are a subspecies of offers. It's not simply the case that you've got Part 36 offers and then all other offers are called bank offers. That's not right. Called bank offer is going to be a settlement offer marked without prejudice save as costs. It's worth bearing in mind you've got WP. That concept without prejudice means it can never go to the court at all. You get WP save as to cost, which means you can put it before the court on the issue of costs, and then you have no reference to WP at all, which may be without prejudice if it's in the course of negotiations or if it's expressed to be an open offer. It can go before the court at any time. Called bank offer will say it's WP save as to cost. It's going to be in writing. It's got to state that it's only going to be accepted in writing and it can give a period of time. If it does that, it constitutes a called bank offer. There aren't any set cost consequences when accepting callback offer, which is why it is deployed very much less frequently than a Part 36 offer. It's when you're dealing with costs at the end under CPR 44.2, there's a court will take into account all the circumstances, including, and then it's got three specific things. One is conduct, one is part of the case, and one is an admissible offer to settle. So you're going to say to the court, I made a callback offer. It is more beneficial than the eventual outcome with the other side, and for that reason, you should give me the costs award that I particularly want. By way of a comparative table between the two, the only meaningful benefit, I think, of callback over a Part 36 is it allows you to wrap the terms as to costs into the offer itself. So if you think, you know, the other side's exaggerating the case, or you've got other reasons for wanting to bind within or include within the actual settlement offer, so things like drop hands or a total payment inclusive of costs, well, that's got to be a callback offer. You cannot have a Part 36 offer that has terms as to costs that are inconsistent with Part 36. So call the bank is there when, you know, you want to, you know, in a sense, agree the principle, but still have an argument about costs. You can put it back before the court, or it's going to be there if you want to do a drop hands or an offer, which is inclusive terms as to costs, like an all-inclusive offer. And where you've made a call-to-bank offer and it's beaten, you put it before the court when you're dealing with costs, but it doesn't have any mandatory consequences, unlike Part 36. On that note, I think we are now at the final Q&A stage. So Ellodie is going to come back and chart us through the choppy waters of questions.
Thank you very much, Tom and Rupert. A special thank you for stepping in at the last minute and covering Kate's talk. I think that was very impressive. I have on my desk one of those horrible boundary disputes that, as you say, Rupert, the court hates. So I shall be picking up tips from Tom on how I might settle it with a Part 36 offer. And if I've still got the will to live after 5 days of arguing it and it doesn't settle, I'll be bearing in mind those points on assessment at the end of it. If anybody's got any questions, I mean, that's been a very comprehensive coverage of the subject by Rupert and Tom. So I'm not sure whether or not we've got many. Is there?
I think there's one question so far. Someone's asked if the paying party is debarred from participating in detailed assessment, so they haven't made their payment on account and someone's got an order, what are the benefits to the receiving party? And the benefits are that if you haven't put in your bill of costs, then you'll be able to get a default cost certificate when because they won't be able to put in points of dispute. And if you've already put in your bill of costs before they get debarred, and that perhaps they've even put in their points of dispute, they won't actually be able to take any role in the actual assessment. So they're not going to be able to turn up and try to explain why things were reasonable or not. Certainly that's my experience, and why it's a good idea to make that application if there is non-payment.
Thank you, Tom. That's very helpful. Anybody else got any more questions before we log off? Now is your chance. Well, there doesn't seem to be any more questions. So thank you once again, Rupert and Tom. Thank you, everyone, for joining us. I hope you found that very useful. And if you have any questions after the event, then do feel free. Oh, hang on. We have another one. Does the court have to take into account the paying party's financial means of paying the costs?
So if that is in the context of an application for payment on account, yes, it is something that the court can take into account. But if you want to show that a good reason for not making a payment on account of costs is that you don't have the money to pay, I think you're going to be in some difficulty. The appropriate thing to do there, I mean, ultimately, of course, you've been involved in litigation and you've lost, so the underlying principle is that you should be paying the other party their costs. It's relevant, I think, if you're making an application to pay in instalments because you want more time and you want to avoid enforcement action being taken against you, and perhaps you want to avoid being debarred from taking part in detailed assessment proceedings. And it's also relevant if you are going to run an appeal, because if you're going to run an appeal and your ability to pay your legal costs and prosecute that appeal is going to be undermined or collapsed if you have to make a payment on account, it's something the court might take into account at that point. But otherwise, starting point is, if you've lost and you're paying their costs, you're going to be making a payment on account, because there's an important underlying policy that people who are entitled to their costs should not be kept out of all of them pending assessment.
Thank you, Tom. Another really helpful answer. Okay. Oh,
I think these are both about detailed assessment. Rupert, do you want to deal with paragraph 1 of that question? Otherwise,
yeah, the short answer is time spent in-house by those who are legally qualified is recoverable as costs.
So Rupert, sorry to interrupt you there. I think just because other people viewing can't actually see the question.
Right.
So the question is, given that in respect to the definition of costs, is the time of a local authority environmental health officer in providing a witness statement and investigation costs recoverable as costs when the local authority is legally represented? Are these deemed to be charges? So that's the first paragraph, Rupert, that I think you were addressing.
Sorry, thank you. You're quite right, Ellodie. The short answer is you're only going to be able to recover costs by those who are ultimately legally qualified. So in-house counsel or in-house legal representatives can recover costs, but investigation costs, in my experience, is relevant to things like private prosecution costs. But that's specific to, the criminal regime under the Prosecution of Offences Act. You quite often get environmental health officers charging in the context of the criminal cost regime, but in the civil cost regime, certainly as far as I'm aware, you're only going to end up paying costs for time spent by legal representatives or litigants in person under the kind of classic £19 an hour type thing. So your answer to that particular question is yes, in the context of private prosecution costs, but not in the context of the civil regime, certainly as far as I'm aware.
Thank you, Rupert. That's very helpful. Do we have time for anything else?
Obviously, so on question, the second part of that question, which is about commencement of detailed assessments. In a case where the receiving party has not served notice of commencement with their bill of cost within 3 months, what are the pros and cons of the paying party applying to the court for an order that they commence detailed assessment by a certain date? That's, of course, a reference to the fact that under the rules, if you delay in commencing detailed assessment, the court has power to disallow you interest. But the advantage of serving the notice of requiring the receiving party to commence detailed assessment is simply that it forces them to set in train the crystallization of your liability and doesn't leave it hanging over forever. Rupert, do you have a view on the tactics of this?
No, mainly because I'm reading the subsequent questions, so I haven't actually.
Oh, I see. Right, well, I'll leave you to answer the subsequent question.
The short answer is there's two particular questions which I don't actually know the answer to, which is why I'm desperately Googling and the answer. But the short answer is there are two questions asking about payments on accounts costs in Part 36. I'm pretty sure.
Oh, well, I can do the first.
Yeah, can you do the first of those? I've certainly been
in Wigan about. So if you settle a low value disrepair matter, say before proceedings have been offered on Part 36 terms, you then have to, if there's no agreement about costs, you then have to commence proceedings, in which case what people I think tend to do is when they serve their Part 8 claim form, they include within that an application for a payment on account. There is some very old and not particularly convincing authority that says that you can't get a payment on account in costs only proceedings. I think actually Rupert rode a coach and horses through that in one of his cases in the Court of Appeal. Yeah, no, I think it was obiter, although I've never managed to persuade a judge that it's obiter. So I think what you can do if a court rejects that, though, is ask for an interim certificate as soon as detailed assessment proceedings have been started. But no, you're not obligated to agree to payment on account, and you can force the other side to make that application and argue it. And if you want to send someone to court to argue that they're not entitled to it, I'll very, very happily go and do that. And if you want someone to go to court and argue that they are entitled to it, Rupert, no doubt, will very happily go and wave one of his many great appeal victories under the district judge's nose and tell them what they should do.
Yeah, and just following on from that, just to reaffirm my own brilliance, in case of Global Assets Advisory and Grand Lane Developments 2019 Court Court of Appeal 1764 was my great victory on that particular point. It's just a shame I couldn't remember it when I originally asked the question.
Thank you very much, both of you. I think that we don't have any more questions. Once again, thank you to everyone for attending the presentation. As I said at the beginning, will be available to you. It has been recorded and that will be sent to you subsequently. Thank you very much again, Tom and Rupert. Thank you very much, everyone.